Hear me, just type yes in the chat. Everyone, if you can hear me, just type yes in the chat. Okay. Chalo. Good morning, Ishwari. Good morning, Sandra. Okay. More and more people are joining. We'll start in a minute. Good morning, Rasesh. Good morning, Soumya. Admit karo, Rahul. कई लोग. Chalo, it's 11:30 and I think we should start. Hello everyone, my name is Anurag Singh. Welcome to Pahuja Law Academy. And today I've been asked to give a lecture on the Indian Evidence Act, the old Indian Evidence Act, or the new one, which is the Bharatiya Saksh Adhiniyam. So this is the Bharatiya Saksh Adhiniyam, right? So as you already know, or you already must know, that this is the new one and the old one has been repealed, right? Although it is said that the old one is repealed, but the provisions of the old one and the new one, they are like, I'm paraphrasing here, but uh, they are like 95% of the provisions are exactly the same. The section number has changed, but the provision is exactly the same, right? Even the illustrations and the explanations are the same as the old one. Okay, there have been changes, yes, but there has been no radical changes or no major changes in the old act or in the new act. Ye old and the new, there are not many changes. The changes that we have are mainly in the electronic evidence part, right? Electronic evidence, this is the part where changes have been made and they have incorporated the major decisions of the Supreme Court over the years. And the IT Act has become more relevant in the Indian Evidence Act or the Bharatiya Saksh Adhiniyam. So that is all not just anything new, because they have been followed by the courts, by the Supreme Court judgments. Now those Supreme Court judgments have now been incorporated to the new Adhiniyam. And not exactly, there have been also changes. The changes that have been made in the new act, in the electronic evidence, they are more like a watered down version of the Supreme Court judgments, right? So we will also look at those, but let me give you an overview of both the acts. They have very similar provisions. All our students, just tell me, have you studied the Indian Evidence Act or the Bharatiya Saksh Adhiniyam? Just tell me, just reply with a yes or no. Have you studied the Indian Evidence Act? Because obviously you will not have studied this, because this just came out. Okay, no, no, okay. Okay, Kiran has. Those of you who haven't, okay, Aditi, Shadan, okay, just let me give you an overview of the Indian Evidence Act, the old one or the new one, because it is going to be relevant in either of the acts. Dekho, the Evidence Act, I'm talking about the old one, right? This is the most important piece of legislation that we have in our statute books, right? This is the most important one, because any party can claim anything, right? But the point is, will you be able to prove it, right? So will you be able to prove it? And that is where Evidence Act comes in and tells ki what can we prove, what we are not allowed to prove, how do we prove it, and who proves it, right? All of these questions are answered in the Evidence Act. This is the old one. So the entire Evidence Act, the old one and the new one, the Bharatiya Saksh Adhiniyam, they can be broadly divided into three parts, right? The first part is what will you prove? What will you prove, right? So the first part is what will you prove, because you will not be allowed to prove anything and everything that the party wants, right? You will have to allow only those things which the Evidence Act allows to be proved. Okay, first thing. Second thing is how will you prove it, right? Suppose one thing is allowed to be proved, the second question is how are you going to prove it, right? And then the third is who is going to prove it, right? So the entire Evidence Act can be studied broadly in these three parts, right? The first is what will you prove, the second is how will you prove it, and the third is who is going to prove it, right? This is a very broad overview of the Indian Evidence Act. Now the first part, this is the most important part. What will you prove, right? In Evidence Act you are allowed to prove facts, but yaad rakhna that not every fact is allowed to be proved. Only those facts are allowed to be proved which are either facts in issue or relevant facts, right? Yaad rakhna, you will not be allowed to prove anything and everything. The party will not be allowed to give proof of everything, any fact. It has to be a fact in issue or it has to be a relevant fact. Now, how do we find out, right? In the old Act, section 5 to 55, this gives you the relevant facts. If any fact is falling under this part, it is going to be a relevant fact, right? So that's a legal relevancy of facts. So the name of the chapter is of the relevancy of facts, and in the Evidence Act we refer it to as the legal relevancy, right? The Indian Evidence Act does not incorporate the logical relevancy, it only incorporates the legal relevancy of facts, right? And by the legal relevancy of facts, what do we mean? We mean sections 5 to 55 of the Indian Evidence Act. The first thing is what will you prove? You are only going to prove facts, not just any facts. It has to be a fact in issue or a relevant fact which are mentioned under sections 5 to 55 of the Indian Evidence Act of 1872. In the new act, it has been changed from 3 to 52, but that's a different thing. Only the section number has changed. Rest of the provisions are exactly the same. Now, first thing, 5 to 55. Yeah, yaad rakhna ki relevancy of facts is in section 5 to 55, and this is what you have to prove. But that does not mean you have to prove each and everything. Okay? Because I'm continuing in this part. I'm going to the next slide. You don't have to prove each and everything. There are facts which need not be proved. Okay? And in the old act, this was section 56 to 58, right? So there are also facts which you don't need to prove, right? Let's take the example. If let's the accused says ki I was in the office, sorry, I was not at the office because it was 2nd October and the office was closed, right? Now 2nd October we know is a national holiday because it is the birth date of Mahatma Gandhi, and this is something which is judicially noticeable, right? This is this is public knowledge. So you don't need to prove to the court that because it was 2nd October the office was closed, right? That is a fact which is judicially noticeable. So section 56 to 58 of the Indian Evidence Act, these are all facts which need not be proved. इसको हम लोग कहते हैं facts judicially noticeable, right? If you have the bare act, you can open section 56. If you don't have the bare act, you can just look at here on the screen. Here we have, you can see section 56, facts judicially noticeable need not be proved. Facts which need not be proved. This is section 56, 57 and 58, right? So yaad rakhna that you don't need to prove each and everything. Facts which are judicially noticeable, you don't need to prove them, right? I'll just give you an example of a public holiday that let's say it was 1st of January. So you don't need to prove that it was 1st of January, right? That is something which is judicially noticeable. Let's say you are saying that I was celebrating Christmas with my friends, right? You don't need to prove that Christmas falls on 25th of December. It is a fact which is judicially noticeable, right? So, याद रखना कि first of all, the first part of the Indian Evidence Act is what will you prove? You have to prove the facts, but not just any fact. It has to be a fact in issue or a relevant fact which falls under section 5 to 55. But still, you don't need to prove each and everything, because facts which are judicially noticeable are not required to be proved, right? This is the first part. Now, even in this first part, there are provisions which fall under sections 5 to 55, but they are still not made admissible, right? Jaise, let's take the example of section 25. I'm still going to the first part. Section 25. Section 25 of the Indian Evidence Act, it says, the old one, it says, confession to a police officer, right? Here we have section 25, confession to police officer not to be proved, right? So section 25, although it falls among the relevant facts from section 5 to 55, but still there are facts within those facts which are not allowed to be proved, like example of section 25. And again, section 26, if you can see here, section 25 says confession to police officer not to be proved, right? Although it falls between sections 5 to 55, but not allowed to be proved. And similar example is section 26, where confession by accused while in custody of police not to be proved against him, right? Again, this is also falls under sections 5 to 55. It is a relevant fact, but it will not be allowed to be proved. So the first thing that you have to notice, ki what can I prove? What will you prove? This is the first part, right? Now, many people have this, some people replied ki yes, I have studied the Evidence Act. Many people have this confusion of what do you mean by a fact in issue or a relevant fact? How do we figure out whether a fact is a fact in issue or a relevant fact? Can anybody answer that question? Anyone? All our students may say, anyone? Can you answer this question? How do we figure out whether a particular fact is a fact in issue or a relevant fact? Anyone? Anyone? Those of you who have not studied the Indian Evidence Act, I'm not expecting the answer from you, but some of you said that you have studied the Indian Evidence Act. That is why my question is to you people. How do you figure out that a particular fact, is it a fact in issue or a relevant fact? Anyone? Okay, I'm taking it as that you're not aware of the distinction between these two. Let's take an example. Let me explain. By an example, I'm going to explain ki what do you mean by a fact in issue or a relevant fact. You are unable to speak, yes, Kavya, because the mic has been turned off, because if we turn on the mic, it's just chaos. Facts which arises dispute is fact in issue. Okay, Shadan, not wrong. Not wrong. Kavya, that is something you have to bear. Even I have to look back and forth towards the screen. I'm reading your comments. The screen is over here. You can type in the chat. Right. Right. Shadan is saying that facts which arises dispute is fact in issue. Right. Okay. Shadan, not wrong. Okay, let me give you an example. Okay, and listen very carefully to this example. Ki is it a fact in issue or is it a relevant fact? Okay, chalo. Okay, Sandra, very good. A very good definition. Okay. Manreet, again, a very good one. Very close to what Sandra said. Anjali, that authority is not up to me. It is to the control, the IT department, and I'm sorry, I don't have authority over that. Affects the dispute before the court. Okay, Prince, again, very close. Okay, okay. Let me give you an example and listen carefully to this example. Anyone, जितने भी लोगों ने definition दिया, it's a good one, but just listen to my example. Okay? Suppose there's a person A and he bought an insurance policy. Right? Now, the insurance company right? Suppose it has in the policy, one of the conditions is that if A commits suicide, his family will not get anything. His family will not get any money, right? So A bought an insurance policy, and the insurance company had a condition in its policy that if A commits suicide, his family will not get any money, right? Now, after some time, what happens is A dies under mysterious circumstances, right? It's not sure whether his death was accidental or intentional, right? Right. Okay, Vishali, again a very good one, right? जो मैं बता रहा हूँ ना, just listen to this and then add on to your ones, ठीक है? चलो. A dies under mysterious circumstances. After A's death, A's family, it insists that A's death was natural, right? But the insurance company, it says A's death was by suicide. So it is an unnatural death, right? Now, when A's family claims the money from the insurance company is obviously going to refuse because of the condition that was in the policy that A had died by suicide, right? Now, here, when A's family files a suit against the insurance company, okay? A's family files a suit against the insurance company. Now, इसमें सबसे पहले the first thing, देखो, the main fact to be determined is whether A committed suicide, right? देखो, listen to this carefully. A's family is saying that A's death was natural, and the insurance company is saying that that A's death was by suicide, right? Now here, the question that fundamentally we are going to ask is whether A committed suicide or his death was natural, right? So this question, okay, just type yes or no, just type yes or no. The answer to this question is going to decide the rights and liabilities of the parties. Yes or no? Just type yes or no. The answer to this question is going to decide the rights and liabilities of the parties. Right? Okay, very good. Now we take this fact, right? We keep it separate. Now let's look at some other facts. Okay? Chalo, some other facts. Other facts. Now, suppose first is A was under severe mental depression, right? A was undergoing treatment. Okay, right. Next, A bought a gun 3 days before his death. Then A was shot from a very close range from the same gun. right? You must have heard about point blank range. So he was shot at point blank range, right? A said to his friend C that, will you take care of my family after I die? Right? Right, Rakshit, you figured it out. Okay, just answer this question. I'm just putting up a question. Just answer this. If we prove all these facts, just tell me, if we prove all these facts, does it not answer our this question? Right? If we prove all these facts, does it not answer this question? Just tell me yes or no. If we prove that A was under severe depression, he was undergoing treatment, he bought a gun 3 days before his death, he was shot at very close range, point blank range, and he said to his family that, but will you take care of my family after I die? Right? Dekho, it's yes, Prince. It proves, we cannot say for sure, but probably he committed suicide, right? Dekho, yeah, and one thing more, we need all these facts. Yaad rakhna, we need all these facts, because one fact in isolation cannot conclusively determine that A committed suicide. Suppose we've proved only, let's call this fact number 1. Okay, if we prove only fact number 1, can we for sure say that A committed suicide? Yes or no? Just tell me yes or no. If we prove only fact number 1, can we say for sure that A committed suicide? No, we cannot. Right? We have to prove all these 5 or 6 facts. 1, 2, 3, 4, 5 facts. Right? We have to prove all the 5 facts. Only then we can come to the conclusion that A's death was not natural and it was probably suicide. Right? देखो याद रखना, the fact, यहाँ पर the fact is A's death, which decides the rights and liabilities of the parties. This fact is a fact in issue. Okay? And all those facts which in connection with each other, याद रखना, all those facts which in connection with each other, because याद रखना, one fact cannot be relevant in isolation. एकदम अपने मन में अच्छे से बिठा लो, one fact cannot be relevant in isolation. It can only be relevant in connection with other facts. So यहाँ पर, that is why we need all the facts. ठीक है? These facts are known as relevant facts. Okay, everyone, did you get the point? How do we figure out whether a particular fact is a relevant fact or a fact in issue? Is everyone now clear? I got some definitions. जितने भी लोगों ने definitions दी थी, can you just type yes or no? Do you have much more clarity about what is a fact in issue or a relevant fact? Right? So any fact which establishes the rights and liabilities of the parties, and in some cases even disability, right? That fact is known as a fact in issue, right? The other one is relevant facts which are not relevant in isolation. They have to be in connection with other, right? It can be the cause, it can be the effect, it can be anything, right? Now we took the example of a civil case, right? Manpreet, I don't remember Manpreet or what, she also gave a I don't know he or she, but Manpreet also gave a definition of fact in issue. All of you who gave the definition of fact in issue, my question especially to you, do you now get it? What I was trying to ask, whatever you wrote in the definition in the chat box was all good, all correct, but I was asking about something else, right, Manpreet? Okay. right? Okay, so now I gave the example of a civil case. Let's take one of a criminal case. Okay, suppose A is accused of causing B's death, right? A is accused of causing B's death, right? So यहाँ पर the principal question, yes, facts that decides rights and liabilities, right, Vishali? That was the point I was looking for. Okay, you were all right giving your definitions. It was a very close one, but not exactly the one I was looking for, right? Chalo. A is accused of causing B's death, right? So यहाँ पर the charge that A will be the charge that will be upon A is whether A caused B's death. Okay, whether A caused B's death. Now, this question, the answer to this question is going to decide the outcome of the entire prosecution. Yes or no? Just tell me yes or no. The answer to this question is going to decide the outcome of the entire prosecution, the criminal charge, right? Whether he caused B's death or not, right? Now, this is the main fact which needs to be established. Either it is to be proved or disproved. Now, let's look at some other facts, right? He had sexually assaulted A's daughter, right? Yes, yes, Kavya, that's the gist of it. That's the gist of it. I'm just giving you an example. Okay. A had been found roaming around B's house 5 days prior to the incident. Since 5 days, not 5 days, since 5 days. For 5 days he was prior to the incident. Okay. The knife that A used to kill B was found from A's basement. Right? A had earlier threatened B to stay away from A's daughter, or he will have his revenge. Right? Just giving you some other facts. Okay, another question, and just the answers can be yes or no, right? If we prove all these facts, does it not answer the main question? Yes or no? Just tell me yes or no. If we prove all these facts, it is going to answer the main question, right? Exactly. So this A caused B's death, this is going to be the fact in issue, and the other facts, these are all the relevant facts. Again, in relevant facts, you can see that if we prove only one fact, right? See, if we prove, let's say, this one, fact number 2, if we prove only fact number 2, can we answer this question? Can we answer this question for sure? Yes or no? Batao. If we only prove fact number 2, can we answer the question, the main question? No, we cannot. We cannot. नहीं हो सकता. Right? याद रखना इसीलिए we have to prove all these facts. ठीक है? Now, there is, we can see that B has sexually assaulted A's daughter. This establishes his motive for the crime. A had been found roaming around B's house since 5 days prior to the incident. This establishes the occasion and opportunity, right? He was looking for an opportunity to kill B. That the knife A had used to kill B was found in A's basement. This is discovery and real evidence. Okay, and then A had earlier threatened B to stay away from his daughter or he will have his revenge. This is the previous conduct of A. Okay, all of this. Okay, so all of this should be combined. Now, just whatever example I have given, I'm just showing it to you in your evidence act. Okay, the old one or the new one doesn't matter, because right, the first fact that we have noticed is here is the motive for committing the crime. If we go to section 8 of the old act, section 8 falls within of the relevancy of facts. Section 8, the motive for committing the crime, that's a relevant fact. When A says to B that you stay away from my daughter or I will have my revenge, that is his previous conduct. So a previous or subsequent conduct, right? Again a relevant fact. Here we have A had been found roaming around B's house since 5 days, that is occasion and opportunity. This is section 7, facts which are the occasion, cause or effect of facts in issue. Occasion of the facts in issue. You can see when the fact in issue happened, this was the occasion and he carved out the opportunity from that occasion, right? Now, here we have again the knife that A used to kill B was found from A's basement. That is discovery, right? So you can see here section 27. When we go to section 27, we are going to have how much of information received from accused may be proved. Here we have the discovery statement under section 27, right? So you can see that we have to prove all these facts in order to establish the main fact, whether A caused B's death, right? So that is the main fact. Now, if you have the bare act of evidence act, just go to section 3, the old one, or the new one you can go to section 2 here, but the definition is the same. The number provision must have changed, but the provision is the same. So here we have, if we look at the definition of facts in issue, okay? Facts in issue, okay? Any fact from which either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. So fact in issue is that fact due to which the existence, non-existence, nature or extent of any right, liability or disability asserted or denied necessarily follows, right? So एक की liability यहाँ पर क्या होगी? He will be liable for the offense of murder, याद रखना, and he will be liable for the offense of murder. But यहाँ पर there is one more fact, the fact number 1, that B had sexually assaulted A's daughter. Now this will create a sort of sympathy in the mind of judge, right? May or may not, but maybe, most likely yes, but may or maybe not. Now that if you have studied IPC or the new one, the Bharatiya Nyaya Samhita, in that when you study section 300 of the old one or the 100 of the new one, there are 2 more things that you study. One is the aggravating circumstances and the second is the mitigating circumstances, right? Mitigating circumstances are those circumstances which reduce the liability, right? If suppose you have, if you have heard about grave and sudden provocation, have you heard about grave and sudden provocation under section 300 of the old one and 100 of the new one? Yes or no? Yes. Now, grave and sudden provocation is a mitigating circumstance, right? Although he has committed murder, but his punishment will be lower, right? याद रखना कि grave and sudden provocation is a mitigating circumstance. So likewise, this can be seen as a mitigating circumstance. So although he will be convicted for causing B's death, that is murder, but it may fall under, let's say, culpable homicide not amounting to murder, or it may fall into murder, but then the punishment will be lower. Okay, so all of these facts, I gave you two examples, one of a civil, this was a civil case, and then this was a criminal one. This was criminal. Okay, just tell me, do you have a better understanding of what do you mean by a fact in issue or a relevant fact? You get it now? Abhi clear hai? Okay. Okay. Chalo. Now that is just the first part of the Evidence Act, which is what are you going to prove? What will you prove, right? The second part is how will you prove it, right? How will you prove it, right? The fact is this, let's say the fact is how do you establish the motive, right? यहाँ पर हम लोग कह रहे हैं कि how are you, A was undergoing treatment, how are you going to prove it, right? A bought a gun, how are you going to prove it, right? These are the things that are needed to be proved, but how are you going to prove it? That's the second question, right? The second question is how will you prove it? Now, the second question can be answered in three ways, right? That means how are you going to prove it? That can be answered in three ways. Well, actually there are four, but one is the but एक जो होता है ना उसको हम लोग सब टाइप में कर देते हैं. देखो, it can be proved by oral evidence. Okay, it can be proved by oral evidence, right? Let's say कि A, when he was threatening B that I will have my revenge if you don't stay away from my daughter, somebody heard it, right? Any person who was there, that can be the person who can give the oral evidence that yes, I heard A say, A threatened B that ki stay away from my daughter or I will have my revenge, right? That is the oral evidence. Or the other one is documentary evidence. ठीक है? Now, this is हम लोगों ने civil वाले में example लिया था. In the civil example, here we have the civil one example. यहाँ पर हम लोग देख सकते हैं कि that A was undergoing treatment or A was under severe mental depression, right? Now we cannot establish this by oral evidence because your and my evidence, if we give evidence that A was under severe depression, we are not experts in this field to determine whether A was under severe mental depression or not. What do we need? We need an expert's opinion. याद रखना. And expert is going to evaluate, or we can just have the doctor who was treating him give an expert's opinion, right? He will give a written report by which you can say yes, now we have the expert's opinion by which you can prove it. Documentary evidence, right? Now the documentary evidence, some people try to separate electronic evidence from documentary evidence, which is logical but also not very logical, because it is both. Logical is because it will be contained in some kind of device, so it's not oral, right? It's not oral, documentary. But even there you will have to prove the electronic evidence. Okay, electronic evidence can also prove the fact which has been recorded, right? देखो, documentary evidence, the purpose of a document is to record, right? You record by figures, marks, words, जो भी you want to use, you are going to record that matter. You are not only going to record that matter on paper, you can also record the matter on your laptop. Suppose आपने word document कोई create किया है, right? You have recorded it, right? If that can be also used as electronic evidence. So some people use it as different. Ki documentary evidence is going to be different and the electronic evidence is going to be different. My personal opinion is they are not really different. Only the modes of recording are different. One you do physically and the other one is on your device, right? But the purpose of both is same, that is recording of the matter. Okay? You can record it in a paper and pen matter, or you can record it on an electronic device, right? Second one. Now the third one, anyone? कोई बताएगा क्या होता है third? Anyone? Is there any third kind of evidence, oral or documentary? Well, I have included electronic evidence in documentary evidence. Otherwise, that would have been third. Anjali, देखो, Anjali का Anjali is right, but also you देखो, all of these things, these are circumstantial evidence, right? These are created by sub hearsay. Ishwari, देखो, not wrong. I'm not saying कि you are wrong or Anjali is wrong, but both can fall under oral evidence, no? Hearsay is also oral, right? The relevancy or the admissibility is going to be a problem, but still hearsay, you know, hear and say, that's oral evidence, right? Okay. Anyone else? What is the third kind of evidence? Is there any third kind, or are there only two kinds? Only these two are there. Okay, Rakshit, very good. Anyone else? Scientific. Again, देखो, what Shanif has said, scientific evidence, true. But the scientist, he is going to give his opinion either orally, or he is going to submit a document in pen and paper, in paper format, or he is going to give an electronic evidence. Again, wo Shanif, it will fall under either two. Shanif, are you getting my point? Scientific evidence, the opinion that he gives, he will give it as oral evidence. He will going to appear in court and going to say that this happened, or he is going to submit a report, right? Again, that is going to fall under these two. Okay? Anyone else? Keep trying. Keep trying. Is there any third kind of evidence? Is there any third kind of evidence? Try karo. Okay, dekho, there is a third kind of evidence, and that is known as material evidence, or also referred to as real evidence, right? याद रखना, in our example that we had used, देखो, right, the knife, याद रखना, the knife that A used to kill B, that knife is material evidence. It's not an oral evidence, it's not a documentary evidence. याद रखना, it's a material evidence. Okay, a blood-stained knife is going to be a material evidence, or the gun that was used in killing A, right? यहाँ पर हम लोगों ने बोला था that A bought a gun, this gun, or the bullet wounds. वो बुलेट जो होगी वो क्या होगी? It will not fall under oral or documentary evidence. It will fall under the third kind of material evidence. ठीक है? So everyone याद रखना, how are you going to prove it? There are three ways of proving it. One is the oral evidence, the second is the documentary evidence, and the third one is the material evidence, or also known as real evidence. Okay? If you want the provision for this, that's section 59 and 60. For this is section 59 and 60. Okay? The provision for material evidence is in section 60 second proviso. If you go to section 60 second proviso, let me just go to section 60 and the second proviso to it. Do you have the Bare Acts at home? All of you? I don't know if you are at home or in college, I don't know. But if you do, go to section 60 and the second proviso. That will give you the provision for material thing. Dekho, here we have section 60 and dekho, the second proviso. Dekho, kya dikhta hai? Provided also that if oral evidence refers to the existence or condition of any material thing other than a document, याद रखना है, any material thing other than the document, the court may, if it thinks fit, require the production of such material thing for its inspection. This is the provision for material evidence. ठीक है ऑनलाइन स्टूडेंट्स, बेटा आप लोग नई चीजें सीख रहे हो, आर यू लर्निंग समथिंग न्यू और इज दिस रिपीटेटिव, यू आर लर्निंग समथिंग न्यू? यस, ओके ओके, चलो ठीक है। नाउ ठीक है, अब देखो यहाँ पर आई थिंक ईश्वरी सेड हियर से, ईश्वरी डिड यू से हियर से? I don't know, I don't remember. I think Ishwari said hearsay, but I don't remember for sure. Now, oral evidence has to be direct, right? Yes, Ishwari. Okay, देखो, oral evidence has to be direct, right? Section 59 clearly says, देखो, sorry, 60 says oral evidence must in all cases whatever be direct, right? Ishwari, this is the provision which impliedly says that indirect oral evidence or hearsay evidence will not be allowed. Okay, so there is no, if you are looking for a specific provision against hearsay, there is no specific provision. But if you take the interpretation, oral evidence must in all cases whatever be direct. So that means the opposite is not true, right? That indirect evidence cannot be admitted. ठीक है, याद रखना इसे, यहीं से हम लोग exactly that is my point, Ishwari. If you brought it up, it's stuck in my mind कि okay ये बताना जरूरी है, right? So oral evidence must be direct, and indirect oral evidence, which is hearsay evidence, will not be admissible, right? The same rule or implied rule is there also in the documentary evidence, right? Now to prove a documentary evidence, what do you need? देखो documentary evidence के लिए there are two ways of proving the contents of a document. याद रखना documentary evidence को भी हम लोग दो पार्ट में डिवाइड करते हैं, right? We divide the documentary evidence into two parts. The first part is the existence of the document itself, right? Was there a document or not, right? And the second one is what are the contents of that document. ठीक है, याद रखना whenever we are giving evidence about the document, it can be in two parts. Was there a document and what was there in the document? ठीक है, so one is about the existence of the document itself and the other is about the contents of the document. ठीक है, so here again we have to go to section 59. Section 59 says all facts except the contents of documents or electronic records may be proved by oral evidence. That means you can prove oral evidence, you can use oral evidence for proving any fact except the content of documents, right? Now for the content of documents you always need a document. Okay, for proving the contents of document you always need a document, right? Now okay, get this, because this is known as the rule of best evidence, right? Oral evidence must be direct, and for proving the contents of a document there must always be a document. This is the rule of best evidence, and it has to be read with section 165 and 136, but we don't have time for that discussion because I was given an hour and I think it's already 12:18, so I have to wrap this up a bit quickly. Dekho, when you are going to prove a document, section 59 says that contents of a document cannot be proved by oral evidence. That means it has to be proved only by a documentary evidence. Very good. Yes, Anjali. But yaad rakhna, a document when it is required to be proved, it can be proved in two ways. The first is the primary evidence. Okay, and the second is secondary evidence. Both of these must be documents. Only then. Secondary evidence has a bit of oral admissions. वहाँ पर आप oral contents, oral admissions आप prove कर सकते हो. But on the whole, we can say you can prove the contents of a document by a document. That document can be a primary evidence or a secondary evidence. What do you mean by primary evidence? Primary evidence is the document itself. primary evidence is the document itself, right? The original document is the primary, Rakshit, document itself. Okay, you don't need to write original document in the primary, you just write document itself. Okay, that's good enough. In fact, if you go to section 61 62, वहां पर it is clearly primary evidence, तो क्या लिखा है? Primary evidence means the document itself. Okay, Rakshit, clear? You don't need to go original document in the primary, you just need to say the document itself. That is going to be the primary evidence. Okay, right? But more often than not, or in the 90% of the cases, the original document will be either with the opposite party who is unwilling to produce the document, or it has been lost or destroyed or cannot be brought to a court, all of those things. Okay, in that case you are allowed to give secondary evidence. याद रखना, it's not always or under all circumstances that secondary evidence is going to be allowed, right? There are only a limited number of circumstances where secondary evidence will be allowed, right? Although they are not limited, they are also numerous in number. यहाँ पर देखना, when we have to give secondary evidence, first we have to prove that, देखो, section 65 of the old act, cases in which secondary evidence relating to documents may be given, right? Or original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved. Let's say I want to sue Rakshit. Okay, I want to sue Rakshit Sharma. He is in the online lectures. वहां पर the document that I am willing to produce is with Rakshit, right? Now I have to produce the document, I have to produce the content of the document, but I don't have the document. I cannot compel Rakshit to produce a document. I cannot, but the court can. But still, if I don't have it, it is not in my possession or power, then what am I going to do? I can produce a copy of the document. Okay, that is secondary evidence. So before giving secondary evidence, you have to prove that your case falls under one of the provisions in section 65 where secondary evidence can be allowed. Okay, everyone, are you getting this point? ये वाला point समझ में आ रहा है? Not in every instance you will be allowed to give secondary evidence. You first of all, you have to prove it to the court that you are entitled among one of the circumstances in section 65 that secondary evidence can be allowed, and then you go to the types of secondary evidence that is section 63, right? Certified copies or copies made from the original by a mechanical process like a photocopy, right? That is going to be right. So yaad rakhna, when you are going to prove a document, the contents of a document can be proved in two ways. Either you produce the document itself, that is primary evidence, or if you cannot bring the original, and you have to say to the court that I cannot bring the original because it is in the possession or power of the other party, or it has been lost, destroyed, cannot be moved. All of those provisions are under section 65. देखो यहाँ पर, when the original has been destroyed or lost, I just gave you this example, when the original is of such a nature as cannot be easily movable. Suppose a person is dying and with his blood he writes something on the wall. ठीक है, याद रखना, a person is dying and with his blood he writes something on the wall or on the floor or anywhere. Now that thing you cannot take out the wall or take out the floor and produce in the court. What he wrote, that's a document. याद रखना, even in a wall if you write, that's a document. You cannot bring the wall to the document, but what you can do is bring a photograph. अब देखो, this is something which is not easily movable, right? वहां पर आप क्या करोगे? आप उसकी फोटोग्राफ को प्रोड्यूस कर सकते हो in the court. ठीक है? So even that has been, when the original is of such a nature as not to be easily movable, even there you will be allowed to give the secondary evidence, right? यहाँ पर देखना, photographs of the original वगैरह भी देखो, illustrations में जो हम लोग जाते हैं ना, a photograph of the original is a secondary evidence of its contents. Okay, it's in the illustration to section 63. So these are the various methods by which you prove the contents of the documents. Oral evidence के लिए rule क्या है? It must be direct, it must not be hearsay. Although there are exceptions to the hearsay rule like dying declaration or res gestae, there are or even admissions can be exceptions, but overall, or the oral evidence must be direct. For documentary evidence, we either need the document itself, or we are going to need the secondary evidence, but you have to prove those circumstances in which secondary evidence is going to be allowed. That is the first requirement, right? Now, right, let's just say section 6. So now we move to the third part, which is who is going to prove it, right? What do you call this? What do you call this? In the Indian Evidence Act, whenever somebody is called upon to give the proof, what does it, what head does it fall under? Anyone? Soumya, Anjali, and I don't remember. Okay, witness can be not wrong. Sanjeevni, Anjali, beta, witness. No, you call upon a witness. Yes, I do get it, but who will prove it? Yeah, it is not upon the witness to prove it. Witnesses are called by the parties, or they can also be called by the court, but it's not. Okay, have you heard about burden of proof? Anjali, burden of proof. Who is going to prove it? This is the burden of proof. The first part is the burden of proof. Okay, who is going to prove it? Right, the burden of proof is upon that party. Okay, and the general rule for burden of proof is whoever alleges it must prove it. Ye yaad rakhna. Whoever alleges it must prove it. That's the general rule for burden of proof or onus of proof. Yes, Ishwari, the claimant, that's section 101, and that's true. But then, if the claimant discharges his burden of proof, suppose claimant ne apna sara ka sara jo bhi proof kara tha, he gave all the proof, right? Now, the burden of proof shifts to the opposite party, and that's onus of proof, right? Anjali, section 102. Yaad rakhna, onus of proof is the shifting of the burden of proof. Excuse me. Okay, so burden of proof is, ab yaad rakhna, you don't need to prove each and everything, because okay, why? Onus of proof keep shifting, right, Manpreet? Okay, just give me the answer to this question. In what cases the party, although it has the burden of proof, but it does not need to prove it? It has the burden of proof, whether the law requires him to prove, him or her to prove, but then it's not necessary for him or her to prove. अंजलि, दैट्स द बर्डन ऑफ प्रूफ नहीं, मैं कह रहा हूं कि पार्टी के ऊपर बर्डन ऑफ प्रूफ है, बट कोर्ट उसे प्रूफ नहीं मांगती है. ऐसा कब होता है? Did you get my question now? Anyone else? The party does have the burden of proof, but the court does not ask for the proof. ऐसा कब होता है? Anyone? Manpreet, Anjali, Ishwari, Soumya? नहीं, रेलेवेंट फैक्ट तो आपको प्रूफ करना ही पड़ेगा बेटा रक्षित, वो प्रूफ करना ही पड़ेगा. ओके, वेरी गुड. अंजलि, प्रिजम्पशन, वेयर द कोर्ट प्रिज्यूम्स. देखो, what is presumption? If the court regards a fact as proved without asking for the proof of it, that's presumption. A party has the burden of proof, but if the court presumes that fact in its favor, it does not need to prove it. Suppose in section 114A of the Indian Evidence Act, it talks about burden of proof. Suppose a female, she accused someone of committing rape, and suppose she says that the sexual relations between those two were not consensual. The court is going to presume that fact in 114A. If you go to 114A, sorry, not right. Presumption as to absence of consent in certain prosecution for rape. यहाँ पर याद रखना, where sexual intercourse by the accused is proved. Sexual intercourse is proved. And the question is whether it was without the consent of the woman alleged to have been raped, and such woman states in her evidence before the court that she did not consent. The court shall presume that she did not consent. She only needs to state it. She does not need to prove that there was no consent. I did not consent to it. Okay? So she has the burden of proof, but the law makes it obligatory upon the court or mandatory upon the court to presume that fact as true without asking for the proof of it. Okay, are you getting this point? That burden of proof hona hi necessary nahi hai, because there is also a case for presumption. What if there is a presumption in the favor of that person, right? ये वाली बात समझ में आ रही है everyone? Anjali, Ishwari, Rakshit, you don't need to prove everything about which the burden is upon you. You don't need to. There are things which the law is going to presume without asking for the proof of it. Okay, so that's the presumption part. Okay, this is burden of proof, and इसी में एक छोटा part होता है हमारा for the presumption. Okay, okay, Sanjeevni, let's I just give you an example of section 114A. देखो, the general rule for burden of proof is whoever alleges it must prove it. If the female is saying that the man raped me, the burden is upon the female to prove that the man in fact did rape her. And rape, it's a very complicated thing to according to the act, but generally speaking, no consent and sexual relations, that's rape, right? No consent and sexual relations, that's it. I know I'm oversimplifying a very complex thing, but still it boils down to this: no consent and sexual relations, right? There, the female, she has to prove two things: that there were sexual relations and the sexual relations were without consent, right? Two things we have to prove, right? Sanjeevni and everyone else, she has to prove two things to prove rape, right? Just answer yes or no. ये दोनों करना पड़ेगा ना बेटा. There were sexual relations and it was done without consent. He has to prove two things. Now, right, अब देखो, in this section 114A, it goes on a premise that where sexual intercourse by the accused is proved. So one thing has been proved by the female, right? She proved one thing, that there were sexual relations between the female and the male that is accused of rape, the accused, right? But the second part is of consent. How is she going to prove that it was without consent, right? How is she going to prove that it was without consent? She doesn't need to prove it, right? Because the law presumes it in that favor. The burden of proof of the victim here is presumed by the law. So the burden of proof, although किसके ऊपर आता है, but actually law उसके favor में presume कर लेता है. That is why she does not need to prove it. ठीक है? That was the point कि कई बार the burden of proof, the general rule for burden of proof is whoever alleges it must prove it. This has exceptions, and one of the exceptions is presumption. If the court has presumed it, you don't need to prove it. Okay, Sanjeevni? हाँ. Did you get my point? अभी clear हुआ? Right. चलो. Okay. I wanted to interact more, but the time is over. So this is section 101 to 114A of Indian Evidence Act. I just gave you an overview of what the Indian Evidence Act or the new one. Even the new one may don't worry about anything new. There are new things, but only in the electronic evidence part, right? 62 to 72 of new one. That's the one where changes have been made, but overall it's the same thing. Okay, so I will have to end my lecture now because the time is over, but मुझे बहुत अच्छा लग रहा था explain करना. Did you learn something new today? आज सीखा बेटा कुछ? Did you? Okay. Okay, just I gave you an overview. Okay, Anjali. Okay. Okay. Chalo. I'll be leaving the meeting now. Okay. Chalo. Thank you, everyone.